board. And let's see. I think I asked you guys when we first met if anybody was doing property management, and I think Shanquinta was the only one. You guys aren't doing property management, considering property management, anything. So, you know, it's just another piece of real estate. Some agents can do both. Some will pick one. There are firms that offer both. So it's just kind of up to our individual preferences. I like that our state, I mean, my license says I can brokerage any transaction as long as the property is located in North Carolina. So they don't regulate me for residential, commercial, property management, you know, Wilmington, Fayetteville, wherever. So we kind of have a broad possibility here with our license. So just a little bit about property management. For those of you thinking about getting into property management, or those of you considering property management, in your real estate manual, Chapter 17 is the property management unit. So if you're heading that direction, if you're thinking about it, I would suggest starting in Chapter 17 because that's the whole unit dedicated. Chapter 19 is all about commercial. So I know when we talk in sales, we talk heavy residential, but with property management, I think you see kind of a mix between residential and commercial. The residential property manager is assisting the owner of the property for dwelling, for living purposes. The property manager in a commercial transaction is helping the owner. Maybe it's a retail center or an office park, that kind of thing. If you're taking, or if you haven't taken, I think it's 303. If you haven't taken 303 yet, they get into a little bit more in commercial. But no matter what, if you're going into commercial, if you're going into property management, even if you're going into residential sales, always take opportunities, any opportunity that you can, for training, for educating, for further growing your career and your profession. I don't know about you guys, but I think training, ongoing training, is key to staying in this business. So if you want to be here for long term, we got to keep growing. And that's no matter what you decide to do. So let's talk about property management. Again, we're in Chapter 17, and we're not going through the whole chapter, but if you're following along, we're kind of starting on page 599. My digital users, Chapter 17 is the very start, the very beginning. So Chapter 17. So the property manager, property management, again, our license allows us to work as a property manager at more education required. And even as a property manager, license, law, and commission rule still applies. We only have one governing body for our real estate license. So license, law, and commission rule is going to apply. Michelle, I'm not sure if you're here, if you can hear me, but if you can, just so you know, your camera is not on. So license, law, and commission rule. We'll talk briefly about our property management agreement. The property management agreement is the agency agreement that the owner of a property uses to hire the broker. So we have agency agreement and property management as well. When the broker is hired, the broker is pretty much an extension of the owner. The broker is acting in the best interest and the best benefit of the owner of the property. Talk more about that in just a second. Even putting property management aside just for a second, any licensing requirement in North Carolina, there are 3 activities required to have a license. The transfer or the manage of real property for others for compensation. And I think this comes up again in property management because it's easy to forget this, not so much for us, but for the unlicensed people out there that are maybe acting as a property management without a license. So let's say, for example, you're not the owner of record. Maybe it's your parents that own the property, and maybe they own a duplex, and they say, you can live in one side rent-free as long as you manage the tenants on the other side. Even though they're your parents, would you need a real estate license? Yeah, because first off, they're the name on the deed, right? Maybe you're going to inherit the property one day, but today they are the name on the deed. But second off, you're not doing it for free, are you? You're doing it for something. That thing in this case is free rent. Is free rent something of value? Heck yeah. So when we talk about compensation, we're referring to anything of value. And we're talking about who needs the license. It's anybody that's dealing, in this case, to manage a rental property for others for compensation. If you're doing it for yourself, what if you own your own home that you're acting as the landlord? You're renting it out. You're already shaking your heads no. We don't need a license now, right? Because now you're not doing it for others. You're doing it for yourself. Everybody with me? All three pieces are required. And again, with compensation, anything of value. I think one thing that we find very unique in property management, we tend to deal more with unlicensed staff, unlicensed employees in property management. Property management unlicensed staff can do a little bit more than the unlicensed employee in a sales office. The biggest difference between the two, the property manager unlicensed employee can show properties for rent. It's so important that we understand that unlicensed employees cannot show properties for sale. Have you guys ever been to a large apartment complex before and you go in the office to see an apartment and the lady or the gentleman takes you out and puts you in their golf cart and drives you around and shows you the complex and maybe shows you the available units? And there's a really good chance that that person doesn't have a license, but because they're employed by the property management, they can do those activities. The unlicensed staff, in either case, property or for rent or for sale, still cannot negotiate. That's where we need that license, is to help others negotiate the terms. So that's still the job of the property management. We could be negotiating, for example, rent, security deposit, term of the lease, those kinds of things. There's also a little distinction we need to make. Property managers may manage an HOA. They may take on an HOA to manage. But the question comes up, what if I live in a community with an HOA? I am a property manager and I'm a member of the board, for example. There's kind of an exclusion to this rule. If the property manager lives in the HOA and is a member of the HOA, they're not required to follow the same laws and rules as if they were acting as the property manager of the HOA. Does that make sense? So they can serve on the board. They're not there as an agent capacity. They're there as a member of that HOA. So they don't have to follow. However, they could still be accountable if something happens, maybe something happens to the funds, if they're mishandled, if they're mistreated. So if you're just living there, serving on the board, you don't have as many rules to follow, but you need to make sure that distinction, there's a fine line in the sand there, right? You're not hired to be a property manager. You just happen to be a licensee that's a member of the board. Does that make sense? Do you have any questions on that? So our relationships with our client, what do you guys think? If you were hired to manage somebody's property, if an owner of a property hires you to manage their property, what do you think you owe them? What duties do you think you owe them? And you can sum it up in 2 words.
Old car.
That's right. That's right. Thank you. So when you're hired as a property manager, the owner is your client, and we owe that owner old car. In a residential situation, most of the time, the tenant is not going to be represented. Most of the time, the tenant's going to come in unrepresented. Now, the property manager is going to be the one dealing with the tenant. They're going to be the one collecting rent every month. They're going to be the one handling repairs and concerns and da 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 da. So the relationship is with the tenant and the property manager. This gets kind of tricky for the property manager now because they need to remember who their loyalty is. They need to remember who their boss is, and it's not the tenant. I think undisclosed dual agency and property management residential can occur because the tenant thinks that the property manager has their best interest. So the property manager just needs to make sure that they proceed properly, keeping the best interest of the owner in mind. Property managers have to follow law of agency license law. We just talked about the residential tenant. A lot of times the commercial tenant may have their own representations. Even then, we're talking about two different firms. So dual agency and property management is really, really, really rare. However, if the firm in one transaction has two clients, now we're in dual agency for property management. But as long as each party has their own representation or the tenant's not represented at all, then we don't need to worry about dual agency. What do you guys think? You can do your head one way or another. In a property management relationship with the owner, do we have to do our working with real estate agent disclosure? I got 50-50 here. I got some going yes and some going no. The answer is the anticipation getting you? No. The answer is no. Working with real estate agent is only required in sales transactions. This is not, you're not hiring me to sell your home in a property management. You're hiring me to lease your home. Not required per commission rule. However, I know for a fact that a lot of property management companies have created a form similar to the working with real estate agent disclosure that they can use. It's an in-house form that they have that they can use to discuss with the owner and also with possible tenants, so they can protect themselves and still have their conversations. What we need to know is commission rule doesn't require it. Yes. Hi.
Hey, so the property manager can pay, the company, the apartment company can pay the realtor a commission? Are they entering?
Yep.
So if
property management, yeah, it might be a commission. It might be like a flat fee. Like I'll pay you X amount every month for you to manage this large apartment complex. And I think in property management, we tend to see for a situation like that, a large apartment complex, we might see a flat fee. If I'm a property manager, some, manage individual single family homes. So you may have 40 properties in the city that you manage scattered all over town. Again, that's going to be a relationship between each owner of those homes and the property manager and the broker. But you get some of these large apartment complex. In some cases, we're looking at 150, 200 units. They're huge, right? So it might just be that's what the property manager does. They manage that one complex, and you're going to pay me X amount each month. So as we mentioned, our property management agreement is an agency agreement. I think that's worth me saying again. The property management agreement is the agency agreement. Once we enter into a property management agreement, I owe you old car. It's creating the relationship between the owner and the broker. As with our listing agreement, the property management agreement needs to be in writing from the onset. Again, and any owner of any property, I cannot perform a single service for you until we have a signed agency agreement. The property management agreement follows all the same rules. We have to have an expiration date. The broker has to sign it. Broker's license number, non-discrimination clause. There is a bit of an exception for a property management agreement. Our property management agreement may allow for an automatic renewal. So we can put a provision in there. Maybe we sign a property management agreement today for a year. So we say today's the effective date, and I'm going to manage your property until October 16th, 2023. We could put a clause in there that as we get closer to a year from now, if you're happy with my services and I'm good with the way things are going and we want to continue, we could have an automatic renewal. So unless either party notifies each other, we could renew for another 30 days or 6 months or for a year. What we're trying to do, what the property manager is trying to do, is form a long-term relationship with this owner. Automatic renewal is not allowed for our sales agency agreements. Everybody good with that? Just for the property management, if the parties agree. So there's some functions of the property manager. Once you hire me, yes, Yanni, sure.
What will happen if the building gets sold? Does the contracts carry on, or it has to stop?
So it's going to end. If I no longer have a property to manage, then I'm out. There's actually provision for that in our property management agreement. If the owner sells, we're going to look at that briefly. We're not going to spend the kind of time that we did in the listing agreement, but it is covered. It is covered in our agency agreement. And to Ziani's point, if I enter into a property management agreement with you, I'm entering an agreement to help you rent your property. Can I use the property management agreement when you decide to sell it? If you call me and say, Julie, I want to sell, does that property management agreement cover that? Generally not. So if you call me and say, I want to sell, now I got to get you in a exclusive right to sell listing agreement. Everybody with me? The property management agreement, unless you have an attorney draft something up otherwise, the property management agreement is probably only good for me to rent your property. So we would need to when you're ready to sell. Now, if they call somebody else, again, there's a provision covered there. So once we enter into the agreement, let's talk about some of the functions of the property management. What are some of the things that we need to do? Probably one of the most important things that the property manager does is prepare a management plan. The management plan is going to include like market analysis, neighborhood analysis, property analysis, property conditions. What's the owner's plan? What's the owner's objective of this property? Obviously to make money, but how much money, how fast? And what can the property manager do to help the owner achieve their goal, achieve their plan? The commission, the real estate commission, advises us to prepare a plan and be in agreement in a plan before we enter into a property management agreement. The commission feels that if we enter into the agreement and then create the management plan, if there's conflict, now we got an issue because we're contracted together. So one of those things when you're presenting yourselves, when you're trying to get the business of an owner to be the property management, you may want to have at least a basic property management plan available so you can use that as kind of your sales pitch. And both of you know you're on the same page before you enter into that property management agreement. The property manager is going to help the owner establish a rental schedule, determine what rate we can rent it for, what rate will get us the most profit. Property managers are also doing CMAs, but instead of finding probable sales price, they're looking for probable lease price. They want fair rent values for the neighborhood, for the area. You don't want to undercharge, then you may have tenants that don't care. You don't want to overcharge, then you have vacancies. So it's kind of a very tight schedule, finding that good tenant. If it's vacant, nobody's making money, are they? We're not collecting rent. If we're not collecting rent, then nobody's getting paid. Nobody's happy. So we want to make sure that rent is comparable, that rent is fair for both parties. And it also helps your client, the owner, make some money. That's what they are, you guys. They're an investor. And what's an investor want to do? Make some money. So that's why they hire us, is to help them make that money in establishing that rental schedule. Another thing the property manager is going to want to do is help or prepare an operating budget. Budgets look ahead. If you're budgeting your household expenses for the year, you're probably doing this around January. And your family, your household may sit down every January and say, how can we budget so we can do birthdays this year, so we can take a vacation, so we can have Christmas presents, right? You're planning the year ahead. And an operating budget is going to be doing the same thing. We're going to help the property manager predict expenses, income. Is there a way we can increase the income or decrease the expenses? At the end of the year, we'll probably do a budget analysis. So we'll take the prediction of the operating budget and we'll compare it to what actually happened this year. And that may help us prepare the operating budget for next year. We got to account for things like inflation, for example. So we just said vacancies are not good. So we want to make sure when we're helping the owner, when the place is vacant, we're marketing the property so we can get a good tenant in there as fast as we can, as soon as we can. Where the property manager advertises the place for rent, I mean, same place where we advertise for sale, right? Print media, social media, online advertising, word of mouth. Try to get a good tenant in there. When we're trying to select and qualify our tenants, property managers are allowed to do a credit check. Remember, I think it's good to remind ourselves, fair housing says what we do for one, we do for all. So if you do a credit check for one tenant, you need to do a credit check for all possible tenants. Make it part of your process, make it part of your management plan. Property managers can also request criminal records. HUD puts up a red flag for us. HUD warns us that any blanket policies of criminal records could have a disparate impact, particularly when minorities are applying. It could be a violation for fair housing. So what we're advised, what HUD says is, well, we can look at the criminal record. That criminal record can't be the only factor we use to decide if you should get the application or not. So no blanket policies. Credit check is allowed, and what you do for one, you do for all. So make sure your process is the same for everybody. The property manager needs to keep all tenant applications, whether they're accepted or not. If you're not accepted, if the tenant's not accepted, then the property manager should provide them why they were denied the application. Document that as well, notifying the tenant is that. And like we said, just make sure that the criminal record isn't the only thing that you're considering. It can be one thing, but it cannot be the only thing. So we have a tenant, we have somebody moving in. Now the property manager is usually the one responsible for collecting rent. They're going to collect the security deposit. The property manager needs to follow the Tenant Security Deposit Act. Tenant Security Deposit Act regulates allowable uses for the security deposit, regulations on where we can keep that security deposit, how that money's handled. Is anybody a landlord? Does anybody have rental properties? Few of you. You guys, if you're unlicensed, you can have your security deposit, either a trust account or an escrow account, or a bond. You could invest in a bond and put the deposit in that. However, once you get your license, security deposits can only be in a trust account or an escrow account. So if you're a landlord, you may want to get your hands on the Tenant Security Deposit Act and make sure license law and commission rule. Guys, remember, once we get our license, we're held to a higher standard because now we have a license and we're dealing with the general public in these rentals. So even though you're doing it for yourself, we're still held to a higher standard. There is a Q&A brochure on landlords and tenants and the Tenant Security Deposit Act. So if you're a landlord, you may want to consider looking at those publications. But the Tenant Security Deposit Act applies to everybody, regardless if you have a real estate license or not. So if you know somebody that's a landlord that's not licensed, again, now that you're all licensed, now they know that you know. So make sure you're following those. The property manager is also going to maintain and protect the property. Usually the property manager has authority to make repairs up to X amount. Whatever that X amount is an agreement between the owner and the property manager. If you hired me to manage your property and I had to call you every day over every little thing, this broke, can I change the furnace filter? Can we do this? I need to rake the leaves. Da, da, da. At one point, you're going to wonder why the heck you're paying me, right? So the property manager tends to have a little bit more authority. They have more decision-making ability. How much? All depends on how much, on what the two agree to in the property management agreement. So if you say, Julie, feel free to make repairs, do whatever up to $500. That means $499.99. I can make the decision myself. $500, I got to call you and say, this is what broke. We need a new HVAC, whatever. Property managers also are the ones that usually have their eyes on the property. So if there's any suggested repairs, needed updates, anything that can increase the value, thus increase the money that we're getting for our owner, the property manager should be making suggestions and recommendations to the owner to help increase their profit, help increase how much they're going to make. The property manager is the one that's responsible for enforcing rules and regulations. Let's say, for example, this single family home is in an HOA. The property manager needs to make sure that the tenant understands the rules and regulations. If it's a large apartment complex, then maybe we're making our own rules and regulations, but they're going to enforce them. If there's a violation of rules or regulations, particularly with an HOA, the HOA isn't going to contact the tenant. They're not going to contact the property manager. Who do they know to contact? They know to call the owner. And if your owner gets a call that your tenant violated a regulation, we have an unhappy owner on our hand, right? So we need to get that resolved and make sure the tenant is aware moving forward. As we said, the property manager is, just think of them as an extension of the landlord. As with any agency relationship, what you share with me is just as good as telling my principal. Any act I do as a property manager, it's in the best interest, the best behalf of my owner. So we're going to perform landlord duties. Again, the property manager has to comply with the Tenant Security Deposit Act. Everybody's got to comply with the Residential Rental Agreement Act. And unfortunately, one of the downsides of property management is sometimes you got to take legal actions against delinquent tenants, squatters. So the property manager needs to be prepared to institute those legal actions. If we have to take a tenant to court, property managers usually want to do that. If you have a squatter, the only way to get them out is to go to court and have the judge issue a summary ejectment. Let me rephrase that. The only legal way to get them out is to go to court and have the judge issue a summary ejectment. I have an acquaintance that works for a large apartment complex. One day out of every month, that poor girl spends down at the courthouse dealing with the legal issues, the tenants. 1 day every month. Is that not like the longest day of the month? I think that poor girl. But it's part of her job. So she's handling these legal actions. It's a large apartment complex, so they're dealing with a lot. But she deals with these legal actions. Property insurance is the responsibility of the owner. The owner owns a property, they have to have homeowners insurance. I got 2 different insurance policies on a rental property, right? We got the owner with homeowners insurance to protect the property. Then we have the tenant with renters insurance to protect their stuff. Even though the property insurance is under the owner, ultimately it is the responsibility of the owner. The property manager may have the ability to make those payments, maybe revisit the policies every year that it's time to renew. Again, it just kind of depends on that authority from the property man or from the owner to the property manager. But they could maintain the insurance if the owner allows. Again, we all got to follow license law and commission rule. So the property manager has to maintain records. How long do they keep records? For at least how many years? There's that. Yep. It's always a good place to start, right? So at least 3 years, the property manager is going to keep records. They keep everything, you guys: receipts, expenses, charges, disbursements, applicants, rejected applicants, document important conversations on the phone, document important conversations in verbal. If you show up to a tenant's property and you guys have a conversation of substance, go home and follow it up with per our email, or at least to your owner, so you have documentation of that conversation. By the way, the property manager in this case isn't just maintaining records for the real estate commission, but they're also going to be retaining records for the owner as well. They're kind of like acting like their bookkeeper in a sense. At the end of the property management agreement, if we're not going to renew, then the property manager needs to turn all that over to the owner so they can provide either for them to use or for the next property management. Questions on what the property manager can do or should do? So let's talk about what they can't do. Commission rule says that the property manager cannot reinvest the owner's profits. It's their money. I can make suggestions. I can say, man, that kitchen is 30 years old. We really need to think about updating that soon. But I cannot reinvest their profits. I also can't file or pay their property taxes on their behalf. Again, the owner is still the owner of record. They are still the ones that are ultimately responsible for the property. So they're the ones that get to pay taxes, not the property manager. So real quick, again, we're not going to spend a ton of time on, yeah, we're going to look at our homework assignment too. But real quick, we have an exclusive property management agreement. Property management forms are the 400 series. So this is standard form 401. The first one is creating that property management agreement. It tells us this is for a long-term rental property. This relationship is between the owner and the agent. Once again, we need to identify the property. And if the owner is hiring you to manage multiple parcels, then we can check this box and we're told to pretty much add another piece of paper and have property address, city, county, state, zip code, other description for each parcel that you're being managed to hired to manage. There we go. Duration of the agreement, it shall be binding upon the effective date and shall be for the initial term of this time period or this date. Not less than X amount of days prior to the conclusion of the initial term, either party may notify the other in writing of its desire to terminate this agreement, in which case it shall terminate at the conclusion of the initial term. If not terminated, the agreement shall automatically renew for successive terms of, is it 30 days? Is it 6 months? Is it a year? So basically it keeps going until one of us ends it. Somebody has to terminate it. It'll keep going, automatic renewal. This is an agency agreement, so we got to talk about our management fees. How do we expect to be compensated? Is it going to be a percentage of the total rent collected? Is it going to be X amount per month that the property is occupied, X amount per month that it's vacant, or other? So somebody just asked about payment. Again, it's completely negotiable. Maybe the property manager has a firm policy on how much they expect to collect, if it's X amount per rent or a flat fee. So we have to have both parties agreement and on board with that. Somebody asked about sale. What if the tenant wants to buy? A tenant occupies the property during the term of this agreement, enters into agreement to purchase. Anytime this agreement or initial term of the lease, owner agrees to pay the agent a fee of X amount, a flat fee, which shall be due and payable upon closing. So we can negotiate a commission in a sense if the tenant's going to buy, if the property owner is going to sell. And again, if you want to help them sell, we need to enter into a listing agreement. This is just for me to manage your property. What happens if we terminate early? This form covers that. If prior to the end of the initial term, owner transfers the property, whether by sale or otherwise, the owner terminates this agreement without legally sufficient cause, or the agent terminates this agreement, owner shall pay agent an amount equal to the fee agent would have been entitled to receive during the balance of the then existing term. So I think that addresses the previous question we got. What if the owner decides to sell? Authority and responsibilities of the agent. Again, this is a bilateral contract, a two-way street. So the agent has to practice reasonable skill, care, and diligence. Offer the property for rent in compliance with all applicable federal and state laws. I mean, not only are we dealing with Residential Rental Agreement Act and the Tenant Security Deposit Act, we're also making sure we're in compliance with Fair Housing, Americans with Disability Act. The property manager is responsible for all of that. Here's our non-discrimination clause that we see in all of our agency agreements. Property manager is going to collect all rent and other charges. Deliver to owner within 45 days. Any execution of a rental agreement. So we have to deliver all instruments in that situation too. Provide owner monthly statements. The owner has a right to know what's going to happen with their money. So I'm going to send, the property manager is going to send reports, send statements on a regular basis. Make arrangements on the owner's behalf for any repairs. The agent may not make arrangements for any repairs that exceeds X amount without prior written approval. So again, if we say $500, that means if it's breaking, it's under 500, I don't have to call and pester you. If I'm calling you every day, you're going to wonder why you're paying me. I don't want you to wonder why you're paying me. Now, anything over that amount, I need to call and have a conversation with you. Answer tenant requests and complaints. Again, the tenant is communicating directly with the property manager. So the property manager just needs to make sure that they remember their role. They remember what side of the wall they're standing on. Don't treat the tenant as a client. Don't lead the tenant to believe that they're a client. Retain such amounts from owner's rental proceeds as may be necessary from time to time to pay expenses associated with managing the property. Agent will establish and maintain a fund on the owner's behalf in the amount of X amount from which expenses may be paid, but owner acknowledges and understands that the agent may from time to time retain additional amounts as agent notifies owner in advance writing or reasonably necessary. Institute and prosecute such proceedings in small claims court as may be necessary. And then we have a place here for anything else, any other additional responsibilities and authority of the agent. So if there's other things that we agree to. How we're going to cooperate with other agents that might bring us a tenant. Again, some tenants are represented, some are not. So if another agent brings a tenant, are we going to cooperate with them? Are we going to compensate them? Spelling that out in our property management agreement. Marketing the property when the tenant leaves. We want to get it fixed up, rentable, and find a new tenant as soon as we can. Again, if it's vacant, nobody's making money. So we want to make sure we have a tenant in place at all times. So to market the property, I need permission to put a for rent sign in the yard, put certain information in MLS. Triad MLS, there's a separate section for residential rentals. So when you go to search, we go to residential sales, but there's also a rental, there's a commercial, there are several different tabs in the Triad MLS, I'm sure others as well. Advertise the property in a non-internet media, and then display the property on the internet, social media for sale. Owner has to represent to the property manager that they're not under bankruptcy, they're not seeking foreclosure. Wouldn't that be something to get hired and then find out they lose property foreclosure, and then what are you going to get? Yeah, that's a big nothing, isn't it? So we want to make sure that they're not going to lose the property. And all past and current property taxes, mortgage payments, associations, assessments have been paid. The owner is responsible for all costs and expenses associated with maintenance and operating the property. The owner's responsible there to provide funds to the agent promptly at the agent's request for any costs or expenses about the property. Not take any action or adopt policy that would affect, of which would be prevent agent from offering this property for rent in compliance with the applicable federal and state laws, ethical duties. Once again, a reminder of our protected classes. I feel like fair housing bumps into more issues with property management than it does for sale. So as the property manager, I mean, as any agent, we need to be familiar with, comfortable with, and very knowledgeable about fair housing. But I think the property manager runs into these incidences and issues more often. So they just definitely need to make sure to always stay in compliance with the laws and the rules, fair housing. Carry and maintain at the owner's expense general liability insurance. So again, we're talking about the owner's responsibilities. They've got to have homeowners insurance. They can require their tenant to have tenant's insurance. Maybe they care, maybe they don't, but the owner's got to have the building insured. The owner's going to indemnify and hold the agent harmless, except to the extent of law. They're going to be responsible, again, for timely payment. There's taxes, mortgages, associations, and then anything else that we feel that the owner should be responsible for. Here's our section on the Tenant Security Deposit Act. Again, if you're a landlord, if you're a property manager, you want to be familiar with this act so you know how much rent or how much security deposit you can collect. They have limitations on that. You also want to make sure the allowable uses for the security deposit. Make sure we're in compliance with that. Are pets allowed on this property? Yes or no? We can charge a non-refundable pet fee. You cannot charge a pet fee if the tenant has a service animal. So if they have a documented disability and they have a service animal, that animal is considered like an extension, like a wheelchair or a cane. However, you can charge a pet fee for a pet. Tenants need to understand that that pet fee is generally non-refundable. They're not paying for the pet's damage. They're paying for the pets to be there. So if the dog still damages the property, that can come out of the security deposit at the end of the lease terms. They didn't prepay for those damages. Does that make sense? They're paying for the privilege of having a pet there. And that's what the non-refundable pet fee is for. You cannot charge that pet fee, as we just said, for a service animal. However, if the service animal destroys the property at the end of the tenancy, you can withhold some of that security deposit to fix it. No pet fee, but you can use the security deposit. Can we smoke on the premises? Cigarettes, cigars, pipes, or other tobacco or lighted product of any kind? Is that allowed or not? Is there an owners association? If so, we need that information. The property manager is probably going to be in touch with the owners association. They're the ones that are going to be reaching out to. We're going to decide who's responsible for paying those fees. Owner or agent is going to pay those association dues. The owner has to represent if we're on public sewer or an on-site septic tank. Are there any occupancy limits? Not just by the septic tank, but in general. Generally, we can figure 2 persons per bedroom. Any other existing service contracts? Maybe you have a cleaner or a lawn care landscaper, somebody that comes by every other week and mows. This is probably my favorite part of this agreement. The owner and the property manager can now go through various costs and actually decide who's responsible for it. You see here, I got some blank spaces here if we need to go back through and list anything here. So it's pretty clear. If there's a home warranty, pest control, HVAC, lawn service, anything like that, it's pretty clear. And we can decide. This talks about our trust account. Entry by the owner. Unless it's spelled out in the lease, we have 0 right to enter the premises. So, and remember, the property manager is an extension of the landlord. So the lease has to say we can enter the property with what, 24-hour notice, 48-hour notice, that kind of thing, in the exception of an emergency as well. But the lease has to spell that out. If the property was built, residential property was built prior to 1978, we're going to notify the tenant of the possible dangers of the lead in the home. There is a lead-based paint hazard addenda for property management. So if you're going, remember that's your 400 series. The 400 series documents are yours. Various information about the tenant. What happens upon the end of the property management agreement? Again, you guys, property management in a sense has been acting like a bookkeeper all this time, right? So they got documents, they got stuff in their possession. So at the end of the property management agreement, we need to decide how are we going to get that property back to the owner? How are we going to get those books and those receipts and those numbers? The property manager may still be on board. You know, the tenant's been paying them rent. So now we need to notify the tenant that they got to pay somebody else, right? So that may take a month or 2. Not everybody may see that notice the first time. So that may take a month or 2 to get that squared as well. In the event that the owner desires to sell the property through their own effort, or those of a firm other than the agent, the owner shall promptly notify the agent that is for sale, disclose to the name of the listing firm, promptly notify the agent the property goes under contract. And in addition, without limiting any fee, may be entered into paragraph 4. Owner agrees to pay the agent a fee of X amount as consideration for transition and sale. So it actually addresses it twice. What happens if the owner sells? And I think this property management covers that. This agreement covers that for us. Boilerplate stuff we see. Exclusive. Exclusive means the owner's dating how many property managers? Just one. They only hired one person to manage. Video surveillance. I can put video up when I'm looking for a tenant when it's vacant, but obviously before a tenant moves in, they deserve the right to privacy. So we need to take those cameras down. You just have it up to protect the home during showings, right? But once we have a tenant before they move in, inside, we're taking those cameras down. Et cetera, et cetera. So I got a place for a couple owners to sign. Here's 4. And then the agent, the name of the firm, who has the authority to sign. Remember, it's got to be signed by both parties, the owner and the broker, with their license number. And then contact information for the owner. What's their address and contact information? Again, this gives us a place for 4 owners. So if you have more than that, then we just do an additional signatures addendum. Questions on the property manager? So the last little piece we have, other topics, we'll get through these pretty quick. I know a lot of this is going to be a review, but there's a couple of things that fall under this other category that we need to cover. Let's talk first about what happens when a broker leaves the firm or changes companies, particularly what happens with your commission. So if an agent leaves their company, can they be paid a commission on a pending transaction that they brokered? You have something under contract and then you leave the firm. Can the firm pay you for that transaction? What do you think? Do your head one way or another. Can they pay you? It depends on the firm's policy, right? So putting the firm's policy aside, that's a good point. Let me rephrase that. Will the commission allow the firm to pay you if you leave a transaction under contract? And that answer is yes, the commission will allow it. Now, whether or not you're going to get paid or not, thank you, depends on the firm's policy. Do I have everybody? Understand, you guys, once it's under contract, that has to stay behind because that's a contract of the firm. So you leave, are you going to get paid on that transaction? Well, as we just learned, Amit said, it depends. The firm may say, if you brokerage the majority of the deal and you did the most of the transaction, sure, we'll pay you something. Again, the commission allows it. The firm's policy also has to allow it. Everybody good with that? So can we? Absolutely. A broker with a current active license throughout the period in which broker services was performed may legally be paid by the company, even if they're no longer associated with that company, or if your license goes inactive or expired at the time of payment. If your license is going to go inactive or expired, the moment it hits inactive or expired, you've got to stop all brokerage activities. We're going to talk about current in just a second. So if the firm determines, for example, that you brokerage the majority of the deal, and as long as you stop the moment your license goes inactive, which means they would have to finish it up for you, you may still get paid. So if you change firms or if you leave your license, lose your license. If you continue brokerage activities when your license is inactive or expired, now you're facing license law and commission rule. Remember, we can only perform brokerage activities with an active license. Questions on this? Very good on this one. Again, it sounds so funny to say. Know the rules before you join a firm. Know what happens if you ever decide to leave. I get it. We're excited. We want to be there. And we have rose-colored glasses on, but we may leave. So we need to find out what happens. We have a commission rule, a duty to notify the commission in writing of any change of our contact information. May that be personal address or firm email address, phone number. Anybody remember how many days we have to notify the commission after the change? Hint, it's not 3. And I see several hands going up, so we're all going to agree that it's 10 days. You guys all now have a licensee log on the commission's homepage, and crec.gov, you can log on. If you're making a change to your contact information, you can do it right there in your online account. We no longer need to send something in. Isn't that handy? Thank you. Thank you for creating that for us. You can manage everything, but we have to notify within 10 days of the change. What happens to your active listing if you leave a company? Well, we've kind of hit on this, and we need to ask ourselves before we answer this, whose listing is it? Is it yours?
Firm.
No, it's the firm's. So what happens to your active listing if you leave? I really can't answer that until I see your firm's policy, can I? Maybe they will let you take it with them. Maybe they won't. Maybe it depends. Did you just list it yesterday? Or have you had it for 5 or 6 months? Does that make sense? The firm will decide whether or not you can take that active listing. What I need you guys to remember, you leave and you go to a different firm, and your old firm says, no, you can't take it with you. So they've reassigned it to another agent in the firm. We need to remember that the code of ethics say we cannot solicit an active listing of another company. So even though today they were your listing, tomorrow they're not. Can you call your former seller and say, I changed firms, do you want to come with me? Everybody shake your head no, because that's soliciting somebody else's listing. Do I have everybody? Now, when that listing expires, can you call the heck out of that seller? Yeah, go nuts. Check your do not call. I think you've had a previous business relationship with them, so that should apply for 18 months. If they reach out to you, I need you guys to carefully document that, because if it ever goes down, you need to show that they reached out to you and not the other way around. Questions on that? Remember, the real estate commission doesn't get involved with money. The commission doesn't get involved with our commission. Kind of easy to remember, right? They're not going to fine you. They're not going to regulate commissions. They're not going to tell you how much you should get paid. If you're not happy with how you're being paid from your firm, find another firm. Do not call the commission and complain. They cannot help you. So it's the firm's policy. What happens when you leave if you still get paid? The commission may allow you to get paid, but that doesn't mean the firm has to.
Julie, who's does the firm then notify the client that you have moved on if you leave?
They'll probably
Since
have
you-
whoever they assign the next listing agent. They'll probably have the listing agent reach out. Maybe the BIC will as well. We've had to make a change. So Sally's going to take over your listing, and she's very qualified, and so somehow we have to notify the seller that the listing agent has changed, because they got a new point of contact now, right? I think that would be a great conversation for the BIC to be involved in, but that's just my personal opinion. You know what they say about those.
Yeah,
have
I
a
was just
question.
wondering.
Oh.
Go ahead.
Go ahead, Armando.
No, I was just asking that question from the perspective of, if I'm an agent and I know I'm going to be leaving, I probably shouldn't be having certain conversations with with my client, or before.
You may want to wait and sign that listing agreement if you can, right? So if the seller calls you today, you may want to politely, in your own unique way, say, how about we list next week instead of this week, right? Like, without saying too much. We need to be very, very careful what we say. Guys, it's been my experience. Buyers and sellers don't care about the firm. Their relationship is with the agent, right? So are most buyers and sellers going to want to go with their agent? Again, that's not their job to understand how that works. It's our job to understand that.
But what if they really want to go with the agent? Can we tell them that in order for that to happen, they have to terminate the contract?
They would. If they do go with the agent, they'd have to terminate the listing with this firm and then basically start all over with this firm. So we got to
But what
sign
I'm
a new
saying-
listing agreement, all that good stuff. Yeah.
But what I'm saying is, can we tell them this is the only way you can actually go with me to the new firm? Are we allowed to tell them that they have to terminate the agreement and
You
sign
need
up
to be
with the
very
new?
careful about that because it's not your agreement to encourage them to terminate. So
I
what
gotcha.
you just did was encourage them to terminate your firm's agreement. Are they happy with you? Probably not. So you need to be very, very careful. I would not make that suggestion. If they want to terminate, they need to get with the BIC because that's who their relationship is with. Does that answer both you guys?
Yeah, I guess, but if you're kind of explaining to them the law, right? You're not really telling them to terminate. You're just telling them the law says 1, 2, 3, 4.
And you can even show them, look,
Yeah,
Mr. and Mrs.
Exactly.
Seller, your relationship was with the firm. It was never with me. You can even show them that, and they may ask, well, can I come with you? You need to talk to the BIC, right? I can't say yes, I can't say no. What I can say is you, the seller, go to the BIC, and how the BIC is going to respond, I don't know, but you with me? I don't want to be accused of interfering in that relationship. I think there's something out there called torturous interference, and it's voluntarily getting involved in somebody else's business relationship. And if you're not affiliated with that firm anymore, I would hate to see you guys go down. I know we want to take that business with us, but we got to just make sure that we're keeping ourselves safe here.
You know what I was gonna say, right? But
Probably. She wants to take them all with her. Yep.
it's not their relationship. But anyway, okay.
I hear what you're saying loud and clear, but what does the form say? Right? This isn't Julie's opinion and Shaquita's opinion. This is, what does the form say? And that's why we have, firms got to protect themselves too, right? If they have a mass exit, if 40 agents leave, are all their listings going to go with them? Or all their buyers going to go with them? The firm's got to protect themselves as well, you guys.
That's happened before.
It has.
Yeah.
It has. You get somebody that starts their own company and says, hey guys, guys, if you haven't been recruited yet by another firm, you will, don't worry. Somebody will call you and say, hey, I just want to take you out for a cup of coffee. They don't want to take you out for a cup of coffee. They're trying to, so there's no law that says you can't be recruited. You guys, you will. I get calls regularly. I joke, y'all, I haven't done a sales transaction. I'm coming up on 2 years. So when I get that call, I think, dang, they don't check the MLS production, do they? They're just calling the roster. If they knew I didn't do sales anymore, they probably wouldn't call me. So I can get out of that pretty easily. But for you guys that are doing sales, for you guys that are directly involved, is there any harm in talking to them? I don't think so. If nothing else, you can get a free cup of coffee out of it. So why not, right? But just know there could be consequences to leaving your firm. Also know the grass is not always greener on the other side. I'm going to leave it at that. What do they say? The grass is greener where you water it. So is it with this firm or is it with a different firm? It all we're the common denominator here, right? So just make sure you proceed according to your firm's policy and of course the commission rules. You guys are, a lot of you aren't going to fall into this category after today, but if a provisional broker leaves the company or their license goes inactive or expired, the former firm can pay the provisional broker directly if their policy allows. The former firm can also pay the provisional broker's new company and have the new company pay them. Remember, the only thing the commission rule says is that the provisional broker can only receive payment from their supervising BIC. So if their BIC supervise them through the majority of this transaction, that BIC can still pay them directly. Or again, maybe they pay the new firm and have the firm pay them. So as a PB, if you go inactive or if you change companies, Just check with your firm's policy. What if you leave the company with a pending transaction? Provisional brokers, you have to leave it behind. Provisional brokers cannot be duly affiliated. The full broker, though, can be duly affiliated. So the old firm may require you to keep your license there until you close that transaction. Full brokers can be duly affiliated as long as we have full permission of both firms. So you could remain, does that make sense? You could remain with the old firm until it closes. You could finish it out because you and that transaction would be under the supervision of the broker in charge. Then once that is done, you can leave that firm for your new firm. Again, it's all down to firm's policy. Questions? Okay, I got one more little piece, but I also see that it's break time. So let's go ahead and take 10. Please come back. We're close. We've got about 10 more minutes or so to talk, and then we're going to do our review and we're going to get ready for this test. Are you guys there? I think I got choppy for a second. So let's take 10. We're back. So the last little piece to talk about before we look at our review, I do want to try to get our homework assignments too, but I don't have those as high priority as I do the review. So we'll just kind of see where we are with those, if we get a chance to discuss those or not. It is on my list. So a couple licensing and education things to go over. Again, you're going to see these anytime you take a post licensing class, they're going to talk about it. Pretty much anytime you take a CE, they're going to talk to you about it. So it's important that we stay fresh and we know how to keep our license going so we can stay in business. So with license statuses, there's only two statuses to our license. It's either current or expired. Is there a difference in a nice, cool, clean glass of milk versus an old carton that's like icky and chunky and everything? So we want to keep your license current. I do think it's important that we understand, that we realize that the commission's physical year, they don't run on a calendar year. They run on a physical year from July 1st to June 30th. So if we want to keep our license current, we need to renew our license every year during the renewal period, which is between May 15th and June 30th. We have 45 days to pay our renewal fee. Whether or not your license is current or expired is whether or not you've paid the renewal fee. A current or an expired license has nothing to do with education. It's all about paying that fee. Last year, and I can't remember for how many years in the past, the renewal fee has been $45. So we have 45 days to pay $45. Of course, that fee is subject to change at the discretion of the commission. If you want a current license going into July 1st, you got to pay that renewal fee by 11:59 p.m. on June 30th. Failure to pay the fee means at the stroke of midnight on July 1st, your license is expired. I don't care if you've done CE or not. This is only about paying the fee. They will tell you when it's renewal time. Your BIC will tell you. You'll get emails. You'll get something in the mail to be on their homepage. It's hard to not know that it's time to renew your license. So the renewal period is May 15th to June 30th. Once you renew your license, you pay that fee. There's a couple different categories for a current license. So once you renew your license, if you've done your education, if your education is up to date, your license will be active. Active is the only status in which you can get paid. It's the only status in which you can promote or advertise your services in any way. If your license is inactive or expired, you cannot even hand out a business card. So the only two things we have to do once you drop your provisional status, the only two things we have to do is pay the fee to keep our license current and do your CE each year. We will talk about CE in just a second. A current license can also be inactive. You're current because you paid the fee, but you're not active. And we'll talk in just a second, a couple different reasons why you may be inactive. What we know right now is if your license is inactive, you cannot engage in brokerage activities. You cannot get paid. No business cards. Examples of why your license might be inactive. Well, half of you have an inactive license. So why are half of you inactive right now?
We haven't finished the post licensing.
No, you're
Not with-
inactive
Not with a firm.
because you're a PB without a BIC. If you're a PB without a BIC, you're inactive. You could be inactive if you don't do your CE. Once you drop your provisional status, you could be inactive because you didn't do your CE on time. You could be inactive by choice. Maybe you think you're done with real estate and you want to give it a break, or you want to put it off to the side. You can ride forever on an inactive license as long as you're paying that fee. You pay that fee each year. When you're ready to activate, they're going to see what kind of CE deficiency you have, post-licensing deficiency. If you've been a while without any education, they may make you go back and get caught up on some education, CE and or post, whatever they decide. Why you would keep an inactive license? I'll answer that in just a second. So everybody good? It's current because you paid the fee. Take current a step further. Is it active or inactive? If you don't pay the fee, that means at the stroke of midnight on July 1st, your license is expired. I don't care if you've done CE or not. I don't care if you've done post licensing or not. It's the difference of paying the fee and not paying the fee. We have to renew each year to keep a current license. If your license goes expired and you want to reactivate an expired license, it depends on how long your license was expired. If it was expired for 6 months, you got to pay the renewal fee and the reactivation fee, which funnily enough also happens to be $45. So you're looking at a $90 fee, resubmit your application to the commission, you're good to go. So you wake up on July 1st and you go, oh my God, are you kidding me? I forgot to pay my fee. It's okay. Pay the fees, do your application for affiliation if you're with a firm. If you're expired for 6 months, more than 6 months, but no more than 2 years, they're probably going to make you come back and do one post licensing class. The good news is that's of your choosing, 301, 302, or 303, whichever one you have the most fun in. Or you can choose, either go back and take a post licensing class, or you go back to PSI Testing Center and pass that test again. What you gonna do? I'd say post licensing all day, every day, but that's just me. If y'all had fun at PSI, then you can go back. If your license is expired for more than 2 years, do you guys know what you got to do?
Start all over
Start
again.
All over.
Yeah. If you didn't have me the first go around in pre-licensing, you got another chance to come back and see me again in pre-licensing. You got to start all over. Is it worth paying the $45 every year and maintaining an inactive license? I can't answer that for you guys. I can't. You have that decision to make. If you think you're done with real estate, you may want to consider paying that $45 a year to keep that license. Otherwise, you got to start all over. Y'all, this happens to licensees all the time. Career change, maybe they move, maybe they're going to start a family, maybe they're going to take time off to care for an elderly parent. Whatever reason, they think they're done with real estate. And then 2 or more years later, they decide they want to get back in, and they call the commission and they're so excited and they say, yay, what do I do? And the commission says, find you a good pre-licensing school because you got to start all over. Y'all know the last face-to-face person class I taught? I had two people that were there because their license had expired. 2. I said, goodness, why did you guys do that? I said, I know, but there they were. They wanted it. Questions on current versus expired, active or inactive? You guys, still for now, our PBs, how do you drop that provisional status? You do your post licensing. Doesn't matter if it takes you a couple weeks, couple months, doesn't matter. You have up to 18 months from the date of licensure. If you don't know what that date is, look at your license. There's a date on the license that starts your 18-month clock. Additionally, as a provisional broker, if you want to be active, you have to be affiliated with a firm. Isn't that some letdown? Congratulations, you passed your state exam. Here's a real estate license on inactive status that you can't do anything with. Good job. Good job. So how do you activate that license? You affiliate with a firm. I tend to think of you guys, I call you my brokers with training wheels. We'll let you go out and ride your bike, but not without your training wheels. So I'll let your BIC get all the training that you can. And please, guys, keep in mind, training does not stop when you drop that provisional status. It's only beginning. Post-licensing is different than CE. You can't get credit for one or the other. They're two separate things. The good news for you guys is you don't have to do CE your first renewal period. Remember, the renewal period is May 15th to June 30th. So when you get your license, the first time you hit May 15th, you do not have to do CE that year. Do your head one way or another. Do you have to renew the first time you hit May 15th? Do you have to send in the fee? Of course you do. So you don't have to do CE that first time, but you do have to renew. After your first renewal period, you have to do CE every year. We're only required to do 8 hours a year. There's a 4-hour update course. If you're a full broker or provisional broker, you'll do the general update, also known as the Gen Up. If you're a broker in charge, BIC eligible, or the designated broker in charge, you do the broker in charge update, also known as the BIC Up. In addition to the update, we do a 4-hour elective, which is a topic of our choosing, as long as it's been approved for CE credit. When it comes to electives, I encourage you guys to take courses that you find interesting, courses that you want to learn more about. Maybe you have a niche and you can find an elective course to help you enhance your niche. Use it not only to satisfy the commission's criteria to take your elective, but use it to help you grow your business. You can be selective about what elective classes you take. You go to ncrec.gov and look under the education tab. Any CE class offered in the state of North Carolina is going to be listed there. So if you're looking for a certain topic, city, online, you can kind of sort. And we have a deadline for CE. And that deadline every year is when? When do we have to have our CE done?
June 10th.
June 10th.
June 10th, every single year. So we renew, we pay the fee between May 15th and June 30th. We do CE by June 10th. No education provider in the state is allowed to offer CE between June 11th and June 30th. The commission has put a blackout period on that time frame. They set the deadline for June 10th. Y'all, please don't wait until June 10th to take your CE, please. Could things happen the morning of June 10th? If you're going to go online, what if there's an accident nearby and they knocked out the pole and you don't have power, if you don't have internet? You're going to go inactive, assuming you paid the fee on July 1st. What if you're going in person and you wake up that morning and you have a flat tire? You're going to go inactive on July 1st. I encourage you guys to try to take your CE. Most schools start offering CE August, September, October. So we have plenty of time to take our CE every year. A lot of agents will tell you that the business just naturally slows down around the winter time, starting with the holidays and kind of slowing down. I did not say we don't do business, but it does slow down during the winter months. Isn't that a great time to knock out your CE so when the spring market rolls around, you're ready to go and you don't have to worry about it? Check with various schools. Lane is one of them that offers CE, but there are many, many, many across the state. And again, if you're looking for a certain topic, I would send you to the education tab on the Real Estate Commission's website. Questions? So the last thing we have to do, let's bring it all home. We've said a lot in the last couple of days together, haven't we? Or me, I know. But we talked about a lot, very specific detail. Again, the highlight of this class, I mean, that's just a fancy way of saying agency. So making sure that we know the relationships that we're creating, making sure that we know our responsibilities. So, exam review. We first started talking about a fiduciary relationship, and we said the fiduciary relationship is one based off of what?
Trust.
Fiduciary, exactly, is a relationship based off of trust. The consumer should trust that they can trust us. I didn't mean to be redundant there, but they should know that they should be able to trust us. That's the basis of this relationship. Guys, please remember, I am a fact finder. When they hire me, I owe them OCAR. If you don't hire me, I don't owe you OCAR. If I owe you OCAR, I owe you the duty of following your lawful instructions. Even though I owe you OCAR, a consumer cannot make me violate license law and commission rule. A consumer cannot make me violate fair housing. The consumer cannot make me violate Americans with Disability Act, Tenant Security Deposit Act, etc. Remember, we're just agents, y'all. We're not attorneys. I can't draft documents. You'll be asked. Your client will ask you. They don't know the limitations of my license. That's not their responsibility. It's my job to know what I can and cannot do. So we need to be prepared when your buyer calls you and says, can't you just put this provision in real quick? What is your answer? Can you do that? And they say, look, I'm your boss. I'm telling you to do this. Just do it. What do we say? Sorry, we cannot draft. We cannot withhold material facts. I think we've beaten that one to death, haven't we? We cannot withhold material facts at the instructions of our sellers or buyers. And also we should not tell them what vendors to use. They're the ones buying this house. They should be able to choose their own settlement service providers, or they're the ones selling this house. They should be able to choose. All we can do is provide them names, give them information. One of the very early things that we're going to do in our relationship is our working with real estate agent disclosure. Again, I'm not trying to create agency. What I'm trying to do is disclose my agency status. We do our disclosure in all sales transactions. We do it no later than first substantial contact. We always need to be on alert when that conversation switches gears from the property to the people. Handing it to them is not enough. We need to review it with them. We need to have a conversation with them about it. And we need to discuss this before I can offer to provide any broker services. I had a buyer customer look at me once when I met her. She wanted to see one of my listings. And I met her at the property and she looked at me and said, I just met you. I'm not signing anything you give me. I said, fair enough. I'm a shady looking character. I get that. If they refuse to sign, that's all we can do is write refuse to sign. If you have a name, put that down. If not, you got man at my open house in a blue shirt, refuse to sign. Make some kind of indication and keep that for your records. If they refuse to sign, can I still offer them brokerage service? Could I continue? If they refuse to sign? Yeah, I'm not asking them to create agency. I'm just disclosing. So just because they refuse to sign, oh, well, have a good day. We're not done if they refuse to sign. We can keep going. We talked about this first substantial contact again, when the conversation switches gears from the property to the person, particularly with the people. When we start discussing price, what are you willing to accept? Acceptable offer price, or what are you willing to offer? How low are you willing to go? How high are you willing to offer? If we start learning about a party's acceptable terms, do they have a preferred closing date, for example? And what's their motive? Is there a sense of urgency? Why are they selling? Why are they buying? That's when we need to say, please stop talking. I owe you this duty to disclose my agency status. I always think sense of urgency comes into place with first substantial contact too. If somebody, let's say you're at a party next weekend and somebody comes up to you and says, I'm thinking about buying, but it's probably going to be a couple years when my kid's out of high school. Is there a sense of urgency there? Is that creating first substantial contact? I'm thinking about buying in a couple years. Y'all know what everybody wants to do in a couple years? Buy or sell real estate. And people will tell you that all the time. What if that person comes up to you and says, man, we got to buy something within the next 3 months? Is that a different conversation? Is that a different sense of urgency? So just because they say, I'm thinking about buying, may or may not be that need for first, or that disclosure, may or may not. I think sense of urgency plays into it. Once you've been hired, when we disclose, our status changes. So if you're a seller's agent and you're communicating with prospective buyers, we have a duty to disclose our status no later than first substantial contact. If you've been hired as a buyer's agent and you reach out to the seller or the seller's agent, we're disclosing our status at initial contact. If I'm reaching out to the agent, I'm not necessarily doing the working with real estate agent. But if I'm reaching out to the listing agent, I still need to let them know who I represent the transaction. Does that make sense? So if you're the listing agent, my buyer's interested and I call you, maybe they have a question on the property and I call you and you answer the phone, I'm going to say something like, hey there, this is Julie Campbell with XYZ company, and I'm working with a buyer that's interested in your listing. When did I disclose the fact that I'm a buyer's agent? When did I disclose my agency status? About the time I got my name out, right? That initial contact. If I'm talking directly to the seller, I'm going to do it with the working with real estate agent disclosure in my hand. Obviously, agent to agent, we don't have to do that, but we still need to disclose our status. They need to know where we are. The real estate commission says, once you do the disclosure at that time, we need to determine in what capacity we're going to work. Don't I need to know now where I'm going to put you in my plane? Am I going to give you first class service or am I going to give you coach? So we need to decide in what capacity we're going to work. Sellers pretty much only have two choices. Either they hire you or they don't. If they do hire you, do they agree to dual agency? Buyers also have choices. They either hire you or they don't. If they hire you, that makes you a buyer's agent. If they don't, that makes you a seller sub-agent. If they do hire you, do they agree to dual agency? Remembering with an oral buyer, we can get agreement to oral dual agency. We talked about some musts for our written agency agreements, anything we have in writing. We need a a termination date. Remember, automatic renewal is only allowed in our property management agreement. Automatic renewal is not allowed for sales agency agreements. The agency agreement is signed by the individual broker on behalf of the firm. The firm doesn't sign these things. I get to sign them on their behalf. And when I sign, I need to include my license number. Our agency agreements are also going to have the non-discrimination clause that says we do not discriminate against the members of the protected class. Our listing agreements. We have to have a signed listing agreement before we can perform any service for the seller. There's no such thing as oral owner agency. Anything we do with the owner has to be in writing from the onset. Our listing agreement needs the names and signatures. I need everybody on board, everybody that's got to sign that deed to convey it, and their spouses. If the spouse isn't on the deed, they still need to sign to convey it. So if it's an estate situation and the cousins inherit grandma's house and there's 9 cousins and all 9 of them are married, I need 18 people signing the listing agreement on day 1. I don't think Judy's going to do that transaction, are you? that got complicated fast, didn't it? North Carolina is a spousal state. How many spouses to buy? Just need 1 to buy, but how many to sell? 2. And guys, there's only 2 answers to the question, are you married? Yes or no. If you're separated, you're married. If you're engaged, you're not. You're either married or you're not. We talked about these limited service listings. Again, what they're limiting is the service, not the duties. They usually have a la carte pricing. They give you a menu, and the items on the menu you select, those are the services you choose, those are the services you pay for. They still owe their clients OPAR. They owe their sellers OPAR. So they have to comply with license law and commission rule. Does a limited service listing have to deliver all offers to their seller? Do they have to deliver all offers? Yes, because what does license law and commission rule say? We deliver all offers. How many days does a limited service firm have to deliver instruments, executed instruments? There's our go-to, 3 days. Again, all license law and commission rule applies. They're just limiting the services that they offer. The listing agent is going to be responsible for all the marketing about the property. Even if you have somebody else doing your data entry, ultimately it's your listing, you're responsible for it. If you have somebody else doing your data entry, I would review it before they hit submit. If you're doing your own data entry, I would have somebody else look at it before you hit submit. Do we sometimes find out that 2 sets of eyes are better than 1? Especially when we're tired and we've been staring at a dang computer screen all day? It doesn't hurt to have somebody else, because once it goes out there, y'all know this about the internet, right? Once it goes out there, it's out there. You're responsible. We can't have any disclaimers to waive our agency duties. You can't just make up zoning because you don't feel like looking it up and then put something in agent only remarks that says buyer's agent to verify zoning. You guys with me? Those kind of disclaimers aren't going to protect you. That's our duty as a listing agent to be responsible for the information in the listing. We talked about FSBOs. Maybe they're going to pay you, maybe they're not. There's no obligation. They don't have to. If the FSBO doesn't pay you, who's going to?
Buyer.
Buyer.
Buyer. So we're going to ask the FSBO, right? Isn't that what my buyer's agency agreement says? I'll always ask the seller first, but if they can't or won't, you have to. It's important that we understand that my loyalty is to the party that hires me, not to the party that pays me. So if the FSBO isn't going to pay me, or the FSBO is going to pay me, my loyalty is still the buyer. And we need to make sure we do our working with real estate agent disclosure with the FSBO so they know where my loyalty is. They know where that is. In this situation, the buyer gets old car, first class. The FSBO gets coach, honesty, fairness, and the disclosure of material facts. If you're working with an unrepresented seller, you are a seller subagent. I'm sorry, what does that say? Unrepresented buyer. Sorry about that. If you are working with an unrepresented buyer, you are a seller subagent. The buyer, for whatever reason, has chosen not to hire you. In this case, we're going to represent the seller. That's the side of the line that we're on. We're hanging out there with the seller. The buyer's over there by themselves, which is what they chose to do. I need to be careful that I don't practice undisclosed dual agency. My loyalty is to the seller. With the unrepresented buyer, I can do a market analysis for them. So if they want to know what to offer, I could generate a report, hand them a piece of paper and say, here you go. When they say, what does all this mean? I need to say, guess you should have hired me. I would put that a little bit more delicately if I were you, but you guys are with me. That's a service they chose not to have by not hiring you. So I can provide them numbers, fair numbers, but I'm not going to advise, I'm not going to interpret. This buyer, I don't owe them confidentiality. You only get confidentiality if you hire me. And again, before you run around and start showing property, you need to make sure that the seller and the listing firm has agreed to pay you as a seller subagent. So what if the listing says, no, we're not going to pay a seller subagent, we're only going to pay buyer's agents. And that buyer, that unrepresented buyer, insists on seeing the home. Well, in a sense, you've received two no's, haven't you? The buyer's told you no, the seller's told you no. Can you yourself go show that property? No, you got two no's. Both parties have told you no. The only way we could get you any money in this transaction whatsoever is if you refer that unrepresented buyer to the listing firm. Let them handle it. Before you release that buyer's contact information, I would make sure you have a referral agreement signed. Make sure that's an agreement. We talked about oral buyer agency. This is an express agreement. Express means all the terms have been clearly stated. Maybe it's in writing, maybe it's verbal. The point with an express is the terms have been clearly stated. So even though it's an oral buyer agency, we still discuss what it means for me to be your agent. We still discuss that I owe you old car. We still discuss dual agency. Don't leave things implied. Don't let people leave people assuming things. Oral buyer agency is non-exclusive, which means that buyer is free to date as many firms as they want to. We can't bind a buyer for a specific period of time in an oral agreement. And bottom line, the latest I have to put that oral agency agreement in writing is no later than the time that I'm ready to present an offer on your behalf. As your agent, I cannot present an offer on your behalf without a written buyer agency agreement. Dual agency, one firm, one transaction, two clients. It's an in-house transaction. The seller has hired the firm to sell 123 Main Street. The buyer has hired the firm to help them purchase 123 Main Street. As a dual agent, do I have a duty to disclose material facts? Yeah, always, always have a duty to disclose material facts. Dual agency, as we discussed earlier, is not always what's best for the client. Remember, my role's changing. I'm still involved in the game, but now I'm acting as the referee, making sure everybody plays by the rules, making sure we get to the end of the game. So I went from being a coach to a referee. If your firm allows it, we may be able to offer designated dual agency. Designated is a form of dual. I got to have permission to do dual before we get permission to do designated. As we said, the provisional broker and your broker in charge can't be designated opposite each other. Any other relationship is allowed as long as you don't have prior confidential information about the other side. If you have prior confidential information about the other side, I don't care who you are, provisional broker, or BIC, you can't be designated. Designated agents or designated agency is always two agents. One has been designated to work, there's that word again, exclusively with the seller. And a different agent within the firm has been designated to work exclusively with the buyer. So maybe the firm has a listing and they get a call on that sign. The buyer wants representation, possible dual agency situation. You've been working with this buyer for 6 months and all of a sudden your firm gets a listing that the buyer wants to see, potential for dual agency. Even though we got agreement to it back in the day when we created agency, now that we're actually here, I think it's important to remind our parties about what this means. If we move forward, this is a reminder about where we are. Designated as a form of dual. Again, I can't have designated without first creating dual. Both require informed written consent of both parties. Dual agency, thus designated dual agency, is intentionally created. We can't just start acting like a dual agent without creating that relationship. That's called undisclosed dual agency, and it is not allowed. We talked about some things we need to be aware of with soliciting business. Article, that should say 16, I'm sorry, Article 16 of our Code of Ethics say I can't solicit somebody else's active client. So if you're already in a written agency agreement, I cannot solicit that relationship. We have to follow the do not call rules if you plan on cold calling. We need to get our hands on that do not call registry and compare it to the number we're getting ready to call, make sure they're not there. And then our Can-Spam Act is in regards to bulk email, mass emails. And what the Can-Spam Act says is we got to give the party the option to unsubscribe. We have to give them an opt-out. We talked about some antitrust rules. Price fixing. The firm sets the compensation. The firm sets the splits. The firm determines how much referral fees they expect to get. All of that is about price fixing. Once again, we need to be very careful how we respond to the question of how much do you charge? Make sure you mention or very clear the fact that this is your firm's policy. Group boycotting, several of us getting together, trying to run Bill out of the business. Sorry, I just saw you first. So we can't get together and decide Bill's a bad agent. We want to push him out of the business. So what can we do to make that happen? If Bill's not a good agent, Bill will work himself out of the business. Bill does not need our help. We can't come together to collaborate and push him out. That's group boycotting. We talked about some documents that we're getting ready for our listing appointment. Some things that we need to provide the seller. One of the very first things we're going to do, of course, is our working with real estate agent. We're going to have a listing agreement ready to sign. As soon as they say, I want to hire you, we need to go ahead and get that signed. We're going to make sure that the seller gets any applicable seller disclosures that they need to complete. So there are codes, MOG, lead-based paint, owners association addendum, short sale addendum, whatever the form is that the seller needs to provide. And then with the seller, we're going to provide them with the property data sheet so we can help gather the information that we need to list their property. They can help. They can help. Aren't they the ones that know their home better than anybody else? So let them help. Let them be a part of it. I always ask my sellers, what's your favorite part of the home? Because if it's their favorite, a buyer may like the sunroom for the morning coffee as well, right? So help them market. The seller should be able to provide us a copy of their deed, their survey, if they still have it, any HOA documents, and then information about outstanding liens. So mortgages, delinquent taxes, for example. If they've had repairs done within the last 120 days, we need to make sure that those have been paid so we don't have to worry about a mechanic's lien. We got to ask the hard questions. Caveat emptor means what?
Buyer beware.
Buyer beware. Caveat emptor applies to the seller and only the seller. You and I don't get to hide under caveat emptor. So no matter how the seller completes the RPODs or any of their disclosures, we still have a duty to discover and disclose. If you're going through the listing appointment and the little red flag goes up, ask some questions. What's that water stain on the ceiling from? For example. The sellers also do have to abide by the Residential Property Owners Association Disclosure Act. That act gives the sellers 2 forms to complete. Can I do this for the sellers? Can I complete this for them? But they're really busy and they got a lot going on and they're trying to find a house and they don't really understand this form anyway. So can I just do this for them? It'd be so much easier for me than if I could, couldn't I? But can we? See everybody's head shaking no. This is a seller disclosure, not a broker disclosure. It's a mandatory form. These are mandatory forms with optional disclosures. And again, regardless how they complete, they have the right to say no representation, but I still have to disclose my material facts. So are seller disclosures required for every single transaction? Do we have to do a disclosure for each transaction? No, there are few rare exceptions. The biggest example, the biggest exception that we have is new construction. Never before lived in dwellings aren't required to complete the RPODs. If it's a court order transferred, maybe it's a trustee or a guardianship or executor in a state kind of thing, they're probably maybe exempt from completing this as well. Just a couple examples for you. And as we said, who completes them? The seller. We can assist, I provide, I can assist. I cannot pick the pen up and do it for them. So what's our compliance with the act? How do we make sure we are in compliance? Well, we need to provide the sellers with the forms for them to complete. We need to remind the sellers of their statutory duty to complete and remind them, if you don't provide this to the buyer, this could give the buyer an out once we're under contract. Buyer has 3 days from receipt or contract formation, whichever one occurs first. If the buyer terminates because they don't receive the disclosures, they'll get their earnest money and due diligence back. When we're talking with sellers, we comply by telling the sellers of their right. You have to complete it, but you can say no representation. You have that right. Interestingly, I think it's good to have that same conversation with buyers. Understand they have to complete it, but they are under no obligation to represent anything. Regardless of how the seller completes the RPOs, the buyer should always be encouraged to do their own investigations. We talked about material facts, specifically things that are material facts. A material fact is anything about the property itself, the roof leaks, the basement floods, extensive termite damage in the crawl space, electrical problems, plumbing, structural issues, just to name a few. Material facts are facts related directly to the property, a proposed zoning amendment, a road widening project, redrawing the school board lines. A material fact is a fact about your principal's ability to complete the transaction. Remember, we say we're going to keep all their information confidential unless required otherwise by law. And this is one of these, unless required otherwise by law. If you find out that your principal, your party cannot complete the transaction, we've got to disclose that. Most of the time, this revolves around money. So we find out your buyer isn't going to get loan approval. Do I have to disclose that? Yep. The seller goes into foreclosure while we're under contract. Do you have to disclose that? Because it affects their ability to complete the transaction. Yeah. No.
I keep freezing, Julie. I'm scared.
Oh, no. We'll get you through it. We'll get you through it. Internet issues happen. We'll talk about it in just a minute. You know what I know about life? We will get through it. Isn't that good advice to all your buyers and sellers? We will get through it. I may not know how at this exact moment in time, but what I do know is we will get through it. The fourth thing is a material fact to me. When my buyer tells me their specific need, when my seller says something of specific importance, I'm not going to put it on MLS, buyer needs a place where they can convert a garage to a hair salon. It's not a material fact that I disclose to the consumers. It's a material fact for me. Does that make sense? It's my super simple philosophy. If it's important to my buyer, then it's important to me. If it's important to my seller, then it's important to me. So we spent some time talking about things that are material facts. We also spent some time talking about things that are not material facts in North Carolina. The haunted house on the block is not a material fact. Any stigmatized property, site of serious convictions, murders, suicides. Something else is not a material fact is the presence of sex offenders nearby. With both of these, I don't have to volunteer the information. However, if I'm asked, I still can't lie. Maybe your honest answer is, I don't know. Maybe your honest answer is, in North Carolina, I don't have to disclose, so I'm going to choose to hide behind North Carolina law. Just be honest. If you are answering, make sure you know. When they ask you if anybody ever died in this house, they're not just asking about current owners, you guys. So if you don't know the history of the home, can you answer that question? No. Sex offenders, be the source of the source. Send them to the North Carolina Sex Offender Registry website. Let them do their own investigations on that. We talked about the prohibited acts surrounding material facts. So if you mishandle material facts, you're either misrepresenting the material fact or you're omitting it. In one word, a misrepresentation is a what?
Lie.
Yeah, straight up. It's just a lie. You somehow put false information out there. Maybe you meant to, maybe you didn't, maybe you knew, maybe you didn't. Regardless of the fact, you somehow put false information out there. You lied. An omission then means you did what? You left it
Didn't
out.
say
You
anything.
kept your mouth shut. You didn't disclose it. So misrepresentation means you lied about it. Maybe verbally, maybe through your advertising, maybe through communicating with another agent, doesn't matter. You got the wrong information out there. An omission means you kept your mouth shut. You didn't disclose it. We talked about lead-based paint. What's the magic year with lead-based paint? Anything built prior to
1978.
1978. It was a good year, wasn't it? So anything built prior to 1978, we do not have to do our lead-based paint. Again, if we are doing the lead-based paint, I'm not telling you there's lead in this home. I'm saying because of the year it was built, it may have lead, and buyers should be encouraged to do their own inspections, their own investigations. Is this nostalgic? I know, I love this picture. I'm like, oh.
So this isn't one of the diligence one that we're supposed to do? The
Say
lead,
it again.
is this one of the due diligence checks we're supposed to do for as a like the seller agent?
Well, as a seller's agent, we're going to help them if the home was built prior to 1978, then we're going to get them the addenda so they can start to complete that. We need to tell the sellers. That's one place that the caveat emptor doesn't apply to the seller. So if they know of the presence of lead in the home, they have to disclose that. As the buyer's agent, we're going to encourage them to, we're going to get them that booklet in their hand to help educate them about lead in the home and encourage them to have that tested during their due diligence if they choose. Okay. We talked about measuring. I said I got to have these three things in order to count it as my heated square foot, total heated square foot, living area. So many different ways we can say that. It's got to be heated by a permanently installed heating system. It's got to be finished according to general accepted construction practices, which means we need a floor, we need walls, we need ceilings. I can't be looking at studs or rafters. What's the required ceiling height?
7 feet.
7 feet, 7 feet. And then it's got to be directly accessible, which means you go from room to room to room of heated finished, room heated finished, room heated finished. If you break up that heated finished, it's not directly accessible. So if you have to go through the garage to get to the stairs for the apartment over the garage, can I count the garage in my total heated square footage? Nope, because it's not directly accessible. Can I advertise that I got a finished apartment over the garage that's, you know, an extra 400 square feet and da-da-da? Can I? Heck yeah, that'd be a good selling point, but I can't put it in my total heated living. The other thing that we talked about were stairs. As long as there's no opening from the roof down the foyer, stairs are going to count on both levels. If I can try to draw a picture. So we
How
have,
about if the garage is heated?
if the garage is heated and finished, now I can count it. That's the trick. The
And if you
garage
go
has to
through
be
the-
heated and finished to count
And
it.
permitted, right?
Well, I can have permitted space. I just have to disclose that it's not permitted. So I can count permitted,
Oh, okay.
unpermitted space. We can count
Okay.
it, but we have to disclose this base that was finished without permits. Good question. Okay. So stairs, like I said, with an opening, you know, in your mind, put the stairs on like a hinge. So if you were to like close the stairs, they're accessible on both levels, right? You could access them on the top level and there's still space underneath. So stairs are going to count in this scenario, stairs are going to count two different places. If it's a situation with like an open space here, there's nowhere to walk here. Now I can only count the stairs just, you know, just where this, I can't count this space because there's nothing to count. I think a good rule of thumb, if it meets these three criteria and you can walk on it, then we can count it. But stairs, as long as they are kind of a hole in the middle of the second floor connecting to the first, then we can count them, both levels. We talked about our CMAs and BPOs. We talked about comps. We looked at some comps. Our comps need to be as similar to the subject. Certain things that we can look at is the type of property. I want like versus like. Is it fair to pull a comp on a condo from a 2-story brick home? Is that really saying the same thing? We want condo to condo, townhome to townhome, ranch to ranch, as similar as we can. Age needs to be similar. I'd say about a, 10, 15, maybe 20-year radius. We don't build homes today like we did back in the 60s, did we? We have different products, different materials, different building codes. So we want something similar to age. Of course, what are the three most important things about real estate? Location, location, location. So when we're pulling comps, I want something nearby. I cannot compare two properties that are, Winston-Salem and Greensboro. I can't even compare two properties that are East Winston and West Winston. We need similar neighborhoods, similar subdivisions, similar area. We need them close by. We want to find comps in similar size, square footage of the building, and lot size. We could be talking about two different sizes. Any number of physical characteristics, how many bedrooms, bathrooms, is there a fireplace, is there a garage? Condition of the property. Is it in good shape? Does it need lots of updates and repairs? Are there any nearby amenities, such as a pool, maybe a neighborhood pool or a clubhouse, for example? Date of the sale, I want recently closed. I want to know what a buyer recently was willing to pay for a similar home nearby. And then condition of the sale. Was it a foreclosure or short sale, for example? May need to take that into consideration. The fewer adjustments you have to make, the better the comp. Understanding no two properties are exactly alike. You're never going to find a comp where you don't have to make any adjustments. No two properties, no two parcels of land are exactly the same. But what I am looking for is the ones with the fewer adjustments.
How do you do a CMA for just land or
How to do a
agricultural?
CMA for what?
For land, empty land, or agricultural land?
So you would just do your fine comps of undeveloped land. So we'd have to look for undeveloped land.
It
That
doesn't
might,
matter.
we may have to have a higher, longer, bigger radius, right? Because there's not as much undeveloped land as there is developed land.
Is there a difference between one side of the city to the other side?
Absolutely. Absolutely. Location, location, location.
Okay, thank you.
Yep. And with land, now you run into things like the topography, location to infrastructure, highways. With their CMA, y'all take the word value out of your vocabulary. You don't get to say value unless you're an appraiser. What we're doing with CMAs is we're determining probable sales price or probable lease price. You guys as provisional brokers cannot do a CMA or BPO for a fee. If you are asked to do a BPO for a fee, we need to personally inspect the property. We need to go put our eyes on it. We need to drive by it, see the outside. We need to go inside. The client that hired you to do the BPO may tell you, don't worry about going inside, but that's a client waiver. We cannot suggest, well, I'll do this BPO and I'll do it for a fee, but I don't have to go inside. That's not me for to decide that. If the whomever hires you to do the BPO tells you you don't have to go inside, they can make that decision. We shouldn't be suggesting it. We looked at our direct capitalization. Did you guys get a chance to review your formula for the net operating income? We start with your gross income, which is the max you can make if you collect 100% rent 100% of the time. How much are you going to make? That's your gross income. From your gross income, you deduct vacancy and collection losses to give you your effective gross income. From there, you deduct your operating expenses to get your net operating income. Keep in mind, net operating income is solved annually. So if they give you monthly rent, times it by 12. If they give you monthly operating expenses, times it by 12. Once we find net operating income, we can divide that by the capitalization rate to determine the value. The direct capitalization approach to value says the value of this building is determined by how much rent does it collect, how much income does it produce. We talked about Regulation Z or ZILA and trigger terms. We said a trigger term was when a specific number was advertised about the loan. Don't get excited when you see a number. When you see a number, ask yourself, is this number about the loan? If it is, trigger terms, Regulation Z says we've hit a trigger term. And now required to disclose all information about the loan. We looked at qualifying a buyer this morning. We talked about opposite world, maximum payment versus minimum monthly income or minimum income. I think there's one of these that might be a little bit more important than the other. So we got to study both ratios. We need to look at our housing expenses, divide that by our 28%. That gives us the minimum income allowed under that ratio, housing expenses only. And then we take our housing expenses and add our reoccurring debt, divide that by 36%. Now I have two numbers. The buyer will get approved on the higher of the two numbers. Minimum income, opposite world, says we're looking for the higher of the two numbers. Again, which one is less risky to the lender? The one that makes more money. So we're looking for the higher of the two numbers. And then just a couple hours ago, we talked about the property manager. Again, you need a license to be a property manager if you're managing a rental property for others for compensation. If you're doing it yourself, you don't need a license. If you're doing it for free, you don't need a license. When we say compensation, we mean anything of value. So maybe they're paying you cash, maybe in exchange for free rent or a tank of gas once a week. Anything of value falls under this compensation. Brokers enter into a property management agreement with the owner. This is our agency agreement. This is what the owner uses to hire the broker to manage their property. Once we enter into a property management agreement, the owner is my client. I owe them OLCAR. Property management agreement spells out how I expect to get paid and when. Day-to-day operations. Any repairs I'm allowed to make without bothering the owner. What is my authority? What is my ability to act in this relationship? And remember too, the property management agreement is the only agency agreement that allows for automatic renewal. Some of the duties we talked about as the property manager, we're going to prepare a management plan. You need to do that early, even before we sign the management agreement. Make sure we're both on the same page. We're going to help the owner prepare an operating budget. What are their predicted expenses and income? How are we going to budget for repairs, updates? Property manager is going to establish a fair rental schedule. Make sure the price is right so we don't have bad tenants or high vacancy. We want to keep a good tenant in there. And then any of the income or the expenses about managing the property. Remember, we said the property manager does not pay the owner's taxes. They do not reinvest the owner's profits. They can do a whole laundry list of things. They can't manage the owner's profits. They can't pay their taxes. That's the owner's responsibility. And then the last thing we said, what happens when you leave? Remember whose listing it is. Always stop and ask yourself, whose client is this? Not unless you start your own firm, you're never going to say you. It's somebody else's client until you start your own firm, of course, then it will be yours. The company may reassign. Remember, If you leave and you cannot take your listing, that is now soliciting somebody else's active client. Today they were yours, tomorrow they're not. So once you leave, you cannot call that seller. That's soliciting somebody else's listing. Is everybody with me on that? We talked about your license status. If it's current, what does a current license mean? If it's current, it means you've done what?
You renewed.
Renewal.
You renewed, and by renewing, how do we renew?
Paying.
You
Pay.
pay the fee. You pay the fee. We renew our license by paying the fee. Renewing,
June 30th.
June 30th. That's right. That's right. We have to renew each year by June 30th. Paying that fee keeps your license current. A current license can be active, which means you can practice. It can be inactive, which means that you can't. Again, current has nothing to do with education. It has everything to do with paying that fee. So you either pay the fee and you're current, or you don't, and you are expired.
Fine.
The difference in active and inactive, that's where it comes down to education. We're looking at two totally different things here. And just to make sure we're good, license law and commission rule says how many days to deliver instruments from execution? It's our favorite number. 3. How many years do I have to keep records?
3.
3. I'm not saying the answer is always 3, but it seems like it's 3 a lot, right? We just said 10 days to change your name. So that's one that's not. I'm not going to say the answer is always 3. Any questions about anything preferably related to 301? We can talk about life in general later if you guys want to. All right, so in just a minute, we're going to take a break. And when we come back from break, we're going to start the exam. But before we take our break, I need you guys just for a few more minutes because I need to go over the rules and expectations of my exam. Maybe you've taken a test with another instructor with Carolina School of Real Estate. They gave their test their way. This is how I give my exam, my rules and expectations. Everybody with me?